But without further ado, we want to pass it over to the lovely, wonderful Emily Gannon, who's going to be taking us through the presentation today. Like Jeff said, use the Q&A function down below for questions, and we'll do our best to get to as many of them as possible towards the end of the presentation. All right. Thank you so much. And
Thanks,
take it away,
Mariel.
Emily. Our pleasure.
Hi, guys. So also keep in mind that this is sort of an interesting topic because it's the legal update. So we kind of cover a couple different things, but your questions, please keep your questions sort of relative to what we're talking about if you can.
Yeah.
Don't start asking me about, other things all under the sun because we'll be here all day. So
And I'm going to mention one thing, Emily, that I failed to mention in my notes earlier. Like I said, this is two purposes, condo board members and managers. Now, when we get to the last slide covering condos only, I will interrupt Emily, make an announcement, put the evaluation link in the chat. And if you're a condo board member, you will be able to leave at that point in time. Managers will have to stay on for the last 7 or 8 slides to get their 2 credits for legal CEU for their September 30 cycle. But again, I'll make that announcement once Emily gets to that final condominium slide. Pardon the interruption.
and for
Back to
you
you.
managers, I'll do those last ones quickly, so don't worry. We'll still get through them. All right, so let's jump in. Let's see. I just had it up. Here we go. All right. Jeff, you see it? We're good?
Yes.
Okay. All right, guys. So this is our lovely little info page here. Little intro about us. I know you probably have heard of us before, but Kaye Bender Rembaum, all we do is association work. This is sort of our thing. Condos, co-ops, and HOAs. Today, I'm sure you guys are all condos. That's what we're really covering today. This is the legal update. But we're here to help you out basically throughout the state of Florida. I'm down in our Pompano office, but we're throughout South Florida. And then we also have an office up in the Orlando area and an office in Tampa. So wherever you are, we can probably help you out. All right, so let's jump in. That's my little profile if you want to read about me. All right, there's a little bit more about the firm. Again, anything your association needs, we can help you redo your documents. We can help you with your collections. We can help you with contracts, all the good stuff. All right, so we start and we have a couple sort of different topics that were covered in this update. We're going to start talking about managers, community association managers, management companies. So to keep it very basic, if you are a CAM, you've probably heard the term CAM before. If you are a board member, maybe you're not sure what that stands for, what that means. When we say CAM, it's a community association manager. We're talking about the licensed community association manager, so the LCAMs, the management companies, those firms that are licensed to provide property management services to associations. And that's really sort of this first section focuses on changes and things that affect our CAMs. All right, so couple things also to keep in mind, sort of in my mind, it helps me think of it when some of these changes kind of have a bit of a theme, if you will. And in the last couple of years, there've been a couple themes we've seen that the legislature has sort of been following. One of them is we're a little concerned about making sure people are doing the things they're supposed to be doing and not, taking shortcuts and or, maybe stealing money. Now, even though stealing money, in theory, everyone should know you shouldn't be doing that. And there's already laws against it. Embezzling is already illegal. It was something or is something that's been in the news in the last couple of years. So because of that, there's lots of concerns to make sure that our management teams, our CAMs are following the law, making sure that the boards are doing the things they're supposed to be doing, making sure we don't have, possible conflicts of interest where maybe people are not acting in the association's best interest because they have other interests in mind. So that's a bit of some of these themes you're going to see. So sort of keep that in mind just to give you some context. Now, again, it's because you may have heard there were a lot of news stories with some very interesting headlines of managers or board members that were stealing money, creating fake companies and paying their, brother fake invoices and all this stuff that was going on. I would say allegedly, but now at this point, I think they were convicted. I think they took pleas, the people who were down in Miami. So that's the context, and that's been sort of a hot topic for the last couple of years. So that's to give you a little background here. So with that background in mind, some of these changes will make a little bit more sense. So we have some new penalties for license revocations. So like I said, CAMs, when we talk about CAMs, we're talking about licensed community association managers. They have to have a license. It is regulated by the state. They have certain rules they're supposed to follow, certain things they're supposed to comply with, certain education they're supposed to continue getting to keep their license active. So if there is an LCAM who has had his or her license revoked, now they've made it clear that they cannot have an interest in basically a management company. So if that CAM had their license revoked, they cannot have an indirect or direct ownership interest, be an employee or a partner, officer, director, trustee of a management company during the 10-year period following that revocation, after the effective date of the revocation. So ultimately, there were some, again, I think some of things that popped up in the news. We had some people who had their license revoked, and then we're still sort of trying to stay around and stay in the game, and still were working with management companies some way or another, even though their license had been revoked. So this makes it nice and clear that's not allowed anymore. Can't do it. If you've had your license revoked, we don't want you basically affiliated with a management company. Good change, I would say, but that's my 2 cents. And that person's going to be ineligible to reapply for certification or registration for a period of 10 years after the effective date of revocation. And I know maybe this sounds a little harsh, but to get your license revoked as a CAM is a pretty serious penalty, and it probably means that they've found that you did a lot of things you probably weren't supposed to, broke a lot of rules. So again, it is a very extreme penalty, but it would make sense probably in context. All right, so some other things for CAMs and the management companies to be aware of. Now they have to create and maintain an account with the department. They have to have basically their online license account with the department. It has to identify what firm they work for, what company they work for, and identify where they're a designated on-site CAM. So if you're a CAM who actually goes to a community every day, condo or if you're on site, you have to actually indicate in the account, where you're going every day, basically, who you're on site for. You have to update that account within 30 days after any change. CAMs have to identify their online licensure account. So the inverse is also true. The management company also has to have the account and identify who their CAMs are and who they employ. Again, this is all sort of to keep track of everybody a little bit better. And if a CAM has had their license suspended or revoked, the department has to will notify the firm as well as the association where they've sort of registered as the on-site person. Interesting, because again, they put it in there that it's really you're registering where you're on site. So the question then we get questions about, well, what if I'm portfolio? I'm not really on site. I have a few different associations that I work with. I'm not entirely sure. They didn't clarify how that goes. I would err on the side of caution if it were me, and maybe still identify which associations you're working with. Why not? And put that in there. But you can follow up and see. But the technical wording is on site. So if you're not on site, I suppose you don't have to identify it. But again, I would better safe than sorry. I'd rather list them. All right. Professional standards, contracts, all of that. So again, this goes along with the same theme I was talking about. Now we've made it very clear that CAMs and management firms cannot knowingly perform any act directed by the association if such act violates any state or federal law. Now, again, I would assume we weren't doing that before, but now we've made it crystal clear, cannot perform any act directed by the association. So even if the board tells you to do something, if you know that it violates a state or federal law, can't do it and then try and say, well, but the board told me to. That's not going to cut it. Now they've made it very clear, can't knowingly perform any act that violates state or federal law. If the CAM, individual CAM or the management company has a contract with the association and that association has to do the milestone inspection or a SIRS, the CAM association or the CAM company has to comply with those requirements too. Any contract between the association and a CAM or a management company has to have now new language they've sort of just added, and has to be in 12-point font. And it's essentially this sentence here that you see in bold. The community association manager shall abide by all professional standards and record keeping requirements imposed pursuant to Part 8 of Chapter 468 Florida statutes. Now, Chapter 468 of Florida statutes is the chapter that essentially governs the CAMs, and that's how they get their license, and it's all under that section of the statute. Now, again, we're making it nice and clear that in the agreement, in the actual management agreement, in the contract that you have with the management company or an individual manager, that sentence has to be in there. So even though, again, it's something that in theory should go without saying, we're saying it. We want to make sure it's in the contract. Your manager is going to abide by all professional standards and record keeping requirements pursuant to Chapter 468 of Florida statutes. All right. And then an important thing too, contract between a manager and the association cannot waive or limit professional practice standards required, also pursuant to Florida statutes, Chapter 468. So again, you can't sort of negotiate around being responsible for your professional practices. All right, some additional duties of some LCAMs. So this was a strange, I guess really this was a strange change 2 years ago at this point. They had added some language in that only applied to HOAs, and now we've made it clear we really meant everybody. So now it means everybody in terms of CAMs. So now this applies to all associations, not just HOAs anymore, all associations. CAMs have to follow the following requirements. They have to attend in person at least one membership and one board meeting per year, or one board meeting per year in person. They have to provide the members of the association and post on the website, if you have to have a website, the name and the contact information of the CAM that's assigned to the association, the hours of availability, and a summary of their duties, and provide to any member upon request a copy of the contract between the association and the manager or the management company. Seems very reasonable. Those are nice changes, I suppose. It was a little strange when before those only applied in the world of HOAs. Why not have it apply in condos as well? All right. Conflicts of interest. So this is another one, like I said, that kind of again goes with the theme we were talking about earlier and making sure everything's kind of on the up and up. We'll put it that way. So we added some language. Now, basically, there's an additional rebuttable presumption of a conflict of interest. So a rebuttable presumption that a conflict of interest exists now, if a CAM or the management company proposes to enter into a contract or another transaction with the association for services other than management services. So, and this does happen, pretty regularly. It's not that unusual. So if the management company also wants to do another service for the association, has another function, another proposal to do some transaction, some service with the management company or with the association, there is now, it's considered a conflict of interest. It doesn't mean you can't do it, but now there's a rebuttable presumption there. Now, instead of listing the entities that could do business with the association, now we've made reference to persons. So any individuals, children, firms, associations, joint ventures, partnerships, estates, trusts, business trusts, syndicates, fiduciaries, corporations, and any other groups, those are now potentially part of this rebuttable conflict of interest. Now, and then they also defined what compensation means. That was another change to the statute. The term compensation, to define it further, basically just says now any referral fee or monetary benefit derived from a person under that provision we just listed, which provides products or services to the association, any ownership interest or profit sharing arrangements with product or service providers recommended to or used by the association. So we've clarified some provisions, defined some provisions that are in that section of the statute. If the association receives and considers a bid exceeding $2,500 for a good or a service other than management services, which could be a conflict of interest under the statute, then the association has to solicit other bids. Now, catch is, this doesn't apply if that matter was disclosed in the management services contract as a conflict of interest under the section of the statute. So that's why I said it's not that you can't do it. It's just if something now is sort of fallen into this category of a conflict of interest, we have to make sure it's spelled out in the management agreement, make sure everybody's on notice, and there's no question down the road. If we put it in the contract and everyone's aware of it, everyone's, again, we're going to keep everybody on the up and up. Notice, transparency. We really want to focus on these things. All right. If a CAM proposes to engage in an activity that is a conflict of interest under the statute, then the proposed activity has to be listed on the meeting agenda of the next board meeting. That board meeting notice has to include a description of the proposed activity, disclose that there's a possible conflict of interest here, and include a copy of all the contracts and any documents essentially that are related to that activity. Again, we're really focusing on transparency, notice, making sure everybody is aware, and nothing's being hidden here. If the board finds that a CAM has violated the statute and basically didn't comply with all of the foregoing, then that contract is going to be voidable, and the association can terminate the contract by sending a written notice. If the contract's terminated, the association's only going to be liable for the value of the services that were provided up to that time. Essentially, they're not going to be responsible for any, penalties, termination fees, liquidated damages, anything like that. It's just going to be basically the value of the services that were provided up to that point. But again, that's why we want to stress we have to comply with this and make sure that the CAMs, those management agreements disclose all of this, and that we're following those notice requirements when it comes to the board meetings, so that we don't stumble into this situation here. All right. So that was our little section on CAMs, the LCAMs, the management companies, all of that. If you're a board member, that might not have been the most exciting thing in the world, so I apologize, but it's important information for you guys. All right, mandatory structural inspections for condominiums. This is the other hot button topic for the last couple of years, as I'm sure you guys know. Not anything really too new. Just some clarification and some definitions that we've kind of narrowed down here. So, mandatory structural inspections. We're talking about your milestone. Now, the way they sort of better defined this for us, which was very nice, milestone inspections apply to buildings that have a residential condominium component and at least 3 habitable stories as determined by the Florida Building Code. So before it just said 3 stories, which got a little confusing for people. What's a story? Does that include a parking deck that's on the bottom floor? Does that not include a parking deck because that's not habitable, that sort of thing. So we get into, well, habitable stories. And that's as determined by the Florida Building Code. So we rely on our engineers to tell us what that really means. But ultimately now we've clarified it does mean habitable. The Board of County Commissioners, or the governing body, essentially your municipal governing body, has to adopt an ordinance requiring the condominium association to essentially the timeframes for commencing repairs after they've gotten the Phase 2 inspection report. A licensed architect or engineer who bids to perform a milestone inspection must disclose in writing to the association his or her intent to bid on any services related to the maintenance, repair, replacement that's recommended in the milestone inspection. This is another one that kind of sticks with the themes we've been talking about: disclosure, conflicts, possible, transparency, and wanting to be making sure everything's on the up and up and above board and everyone's aware of everything. This is in that same theme. So if you have an architect or an engineer who is going to bid on your milestone inspection, but then they're also going to want to bid on the services that the milestone inspection recommends, it makes sense. They have to disclose in writing that information so that you don't say, well, but maybe they're only recommending that we do XYZ because they want the job and they want to make it a bigger job. So that's why they want to do the work for the XYZ, and that's why they did it. I would assume that is not what is going on, but now this makes it crystal clear. Everybody's aware and everything's been disclosed. All right. So also, again, kind of staying with our themes of various conflicts and all of that, any design professional or contractor who submits a bid for performing any services recommended by the milestone inspection cannot have an interest directly or indirectly in the firm or entity that provides the milestone inspection, or be a relative of any person who has such an interest, unless that relationship was disclosed to the association in writing. So again, same kind of thing. We want to make sure there's no question and everybody's disclosed every connection, essentially. So if a contractor wants to submit that bid and they had a connection to the person who again did the milestone, we need to make sure that's all disclosed and out in the open. And then if the board proceeds to use them, great, it's been disclosed, not a problem. A contract for services is voidable and terminates upon the association filing a notice terminating the contract if that design professional or contractor essentially failed to disclose that relationship. So again, we're sort of in the similar boat here of if we don't disclose and we don't announce these things in advance, the association could then terminate the contract. It could be considered void. And same thing in terms of, and a more significant penalty, that design professional or licensed contractor could also be subject to discipline under their, basically against their license. Local enforcement agencies. Okay, so hopefully this is something that is actually happening, but who knows? So on or before December 31st of 2025, and then every December 31st thereafter, the local agencies responsible for these milestone inspections are supposed to basically send the department a certain information, certain disclosures, so we can kind of track what's going on, track who's doing all their milestones. Again, I hope they're doing it. I don't really know. So this is the information they're supposed to include in these reports and these electronic submissions. The number of buildings that are required to have milestone inspections that are within their jurisdiction, the number of buildings that have completed the phase 1 of the milestone, the number of buildings that were granted an extension, the number of buildings required to have the phase 2, the number of buildings where phase 2 has been completed, and then the number, type, value of the permit applications received to complete the repairs for the phase 2 portion, a list of buildings that are deemed unsafe or uninhabitable, if there are any of those, hopefully not. That has to be included on this list. And then the license number of the building code administrator, who is basically in charge of that, local enforcement agency. So we are keeping kind of records now and tracking these things and making sure by keeping tabs on the local agencies that this is being done, that the milestones are all getting done. All right, so now let's get into sort of general condominium association updates. All right, so these were some changes to 718 that were kind of interesting. So since the world of COVID, now you guys, I'm sure, and if we were in person and if this were a live seminar, I would ask you, for a show of hands, but don't worry about it. I'll assume some of you are going to raise your hand. A lot of now communities use Zoom when they do their meetings. It makes life a lot easier. We also, in South Florida, we have a lot of owners who are snowbirds or who travel internationally or whatever it is. And it's nice when you can still make it to that, board meeting while you're sitting on your cruise ship or whatever it is. And you can see what's going on with the community while you're, up in Canada. So lots of Zoom meetings. What does that mean? Can we just continue business as usual and have Zoom meetings? Well, yes, you can have your Zoom meetings, but for condos, and if you're a manager, don't get confused because HOAs are a little different here. For condominiums, they put in 718 a definition now. Video conference, that term video conference was added in here to mean real-time audio or video-based meeting between 2 or more people in different locations using video-enabled and audio-enabled devices. And it's interesting the way they said audio and video. So there was a question about, well, so is this going to apply when maybe we're doing the Zoom, but we don't have cameras on? We don't have any video? Good question. So the notice for any meeting that's going to be conducted by video conference, so video conference, basically Zoom or Teams or one of those other similar platforms, must have a hyperlink and a call-in line for any unit owners so that they can attend that way. There has to be a physical location as well for your unit owners to attend in person. So if you're doing these video conference Zoom meetings, again, we would tell you, even if all your board members are scattered around, it's the summer, they're traveling, they're doing whatever, maybe get your manager or ask your manager to come and do it from the office in the building or the lobby in the building, so that there's a physical location as well. And maybe it is, all your board members are on Zoom, but maybe if you have 1 or 2 owners who want to show up, great, there's a physical location where they can come and do that as well. All the meetings that are conducted by video conference have to be recorded now. So before, if you were doing them by Zoom, maybe you didn't bother recording. You would just keep minutes and that's it, and all well and good. But now if you're holding them by Zoom, or again, by whatever, a similar platform, Teams or whatever it is, make sure you're recording that and keeping that recording. That recording is now part of the official records and you have to maintain it. So again, a little bit of a change, a little bit of clarification for everybody, because this was sort of becoming business as usual. So now we need to make sure we're really following these new rules. All right, associations and CAMs and sort of the interplay. And I talked about all the new CAM stuff before, but if you're a board member, this is important for you too, and here's why. Now, any director or officer of an association that contracts with a CAM or with a management company, now you have an affirmative duty to ensure that that CAM or that management company is properly licensed before entering into the contract. So now they've really kind of put this on you guys as board members. You can't just kind of stick your head in the sand and ignorance is bliss. You have to make sure you have a duty now to make sure that the manager you're working with, the management company you're working with, is properly licensed. And people say, well, I don't know how do I even do that? I don't know how to do that. You can do a little Google search. Basically the DBPR, you can do a search of, hey, license in Florida, blah, blah, blah. And there is a menu that will come up and you can put in the person's name or their license number, and it will confirm that they are a licensed community association manager, or, they have some other license in Florida, but that will come up and there is a way to search that. So now as a director or officer, that obligation is on you as well. You can't, like I said, you can't stick your head in the sand and just say, well, I thought he had a license. He told me he was a licensed manager. That's not going to cut it. If the contract between the CAM and the association, if during that time that CAM gets their license suspended or revoked, the association can terminate that contract. That's nice. That's convenient. Again, because of those various scandals, I think we had people who said, well, just because the CAM got suspended, the management company can still work with them. Well, now the association can terminate the contract without a whole big hullabaloo. If the management company also gets their license suspended or revoked, same thing, the association can terminate the contract, regardless of, whatever else the contract might say. Insurance. All right, everyone's favorite topic, I'm sure. So every condo has to have adequate property insurance, and there's a lovely section of the statute. It's been that way for a couple years, but they made a couple small tweaks this year, and that one small tweak might be pretty significant, actually. The amount of adequate insurance coverage for full insurable value, replacement cost, or similar coverage may, and it used to say must, but the statute changed must to may be based on the replacement cost of the property to be insured as determined by an independent insurance appraisal or an update of a previous appraisal. The replacement cost must be determined at least once every 3 years at minimum. That's a lovely little section of the statute. Again, they changed one word, but the one word they changed is significant. We went from must to may. So mandatory to permissive, but is it really? Probably not. You probably really still need to assume it. It says, it almost read it as a must still. Make sure you are getting proper insurance. You're relying on your experts. You're following what you're supposed to do, looking at your appraisal, making sure your appraisal is up to date and it's full insurable value. Now, I think they changed it to may, and again, this is my 2 cents. People say because, there were some associations that basically weren't able to get proper coverage, or it was just too expensive. And then maybe it was sort of to help them give them an out a little bit. But if you're a board member, you have a fiduciary duty. If you are underinsured and something happens, I think there's, significant liability there potentially. So talk to your counsel. Don't go back and go, well, we can get less insurance because now it says may, not must. Talk to your counsel before you make any decisions like that. All right, skip this part. Official records, another hot topic over the last couple of years. So again, clarifications to the statute. Now, basically, in addition to the list of what was there before, of what you have to maintain as part of your official records, the association has to maintain a book or books or electronic records. They added that as an option, so you don't have to have an old-fashioned, actual binder. Electronic records that contain the minutes of all the meetings of the association, the board, committees, all of that, and then recordings of all of the meetings that you conduct via video conference. So we're back to that topic. If we're doing video conference meetings, so any Zoom meetings, you have to record them, and then those recordings are part of the official records. You have to maintain them. If we have approved minutes for a meeting that's held by video conference, the recording has to be maintained for at least 1 year after the date the video recording is posted on the website. So 1 year, you're going to have to post it on the website and then keep it up there for a year. And then now they've also added a little tweak to this part. Accurate, itemized, detailed records of all receipts and expenditures. That was already there, but now they've clarified, including all bank statements and ledgers. And then a copy of all affidavits required by Chapter 718. So that means your affidavits related to your milestone or your SIRS, so all of that. Those are kind of new things in the last couple of years. So they just clarified you have to maintain copies of those affidavits. The bank statements and ledgers was an interesting change. A lot of us would assume that's part of the official records you were already maintaining and part of the official records that would be open for inspection and all of that. But I guess there were some questions about bank statements, ledgers, and managers or boards sort of keeping those as private information that the owners can't see that. It's secret, it's sensitive. We don't want them to see our bank accounts. You have to keep the bank statements and the ledgers, and owners get to see that. All right. More stuff on official records, because again, hot topic in the last couple years. And if you're, again, kind of keeping my narrative in your mind with the context, this was part of the problem for all those owners who were trying to get to the bottom of, sort of the various fraud that was going on in some of these cases you heard about on the news. They couldn't get copies of records. They weren't given access. Everything was being hidden because, of course, they were covering up crimes. So, hey. So, to make sure that doesn't happen, we've now kind of tightened up the requirements for official records and disclosures. So a director or a member or a CAM who willfully and knowingly or intentionally violates the official record inspection requirements commits a misdemeanor of the second degree and must be removed from office and a vacancy declared. So this is a big punishment. So we want to make sure if you have an official records request, get with your counsel, make sure you're addressing it, responding to it properly, timely, all of that. Now, it is not just an accidental, we didn't realize it was a records request, or we didn't mean to leave out a document, whatever it was. This is willfully and knowingly or intentionally violates. So there is still some intent required there. But again, it's a criminal penalty now, a misdemeanor of the second degree if you don't do what you're supposed to do. Now, in addition to maintaining an adequate number of copies of the governing documents and the question and answer sheet, the association has to maintain the most recent annual financial statement and the annual budget. And the association can charge its actual cost for preparing and furnishing those documents to anyone who requests them. They just added that little section to the statute too. Websites, when we talk about official records, that ties to our website requirement. They're not exact. They don't completely sync up. Your website, what you have to have on your website is not everything that you have to have in your official records necessarily, but obviously they are related. A document has to be made available on the website or for download through a mobile app if you do it that way within 30 days after the association has received it or it's been created basically. So 30 days, that's your window to get it on the website. All right. And then in addition to that, the association has to post the approved minutes of all board meetings over the preceding 12 months. And as we said, any video recording or a hyperlink to the video recording of any of the meetings that were conducted over the preceding 12 months. And then copies of the affidavits required by Chapter 718. Like I said, the affidavits related to the SIRS milestone stuff. So that's the stuff now that we've added to your website requirement. Those are all official records, now also need to be posted. Now remember, since January 1 of 2026, if you're a condo association with 25 or more units, so that's almost everybody it seems, you have to have a website and you have to be following the website requirements. All right. Financial reporting. They changed this just a little bit, but it's a helpful change, I would say, to most boards because financial reporting is not always the most timely of things completed. So within 21 days after the final financial report is completed by the association or received from the third party, but not later than 180 days. So before it was a 120-day window, now it's 180. So we got a little more time there. After the end of the fiscal year or the other date indicated in your bylaws, the association has to deliver to each unit owner a copy of the most recent financial report or a notice that it's available. Evidence of compliance with this delivery requirement must be made by an affidavit executed by an officer or a director of the association. And if approved by a majority vote of all the voting interests, so before it used to be a majority of those present, basically, as long as quorum was obtained, which could be a much lower number, obviously. So majority of everybody, the association can prepare an alternative report instead of the compiled, reviewed, or audited financial statements. They could do something lower, but it's a higher voting threshold to approve that, which again kind of goes with our whole transparency, making sure everything's on the up and up theme. All right, investment of association funds. This was an interesting change because I think there were a lot of people in this field who said that this was already a thing and you could already do it before, but now we've put it in the statute. So a board, in fulfilling its duty to manage operating and reserve funds of the association, can use best efforts to make prudent investment decisions that carefully consider risk and return in an effort to maximize returns on invested funds. Okay, so that gets a little complicated because keep in mind that the association's, funds, these are the association's funds, right? It's not a individual board member, even though that person might be very successful. Maybe they're in this world of, whatever it is, investing and all of that. It has to be a prudent investment. You're not going to invest in, or could you? What does that really mean? What is prudent? Are you going to invest in some new cryptocurrency that gets released? Probably not. Probably not a good idea. So again, we kind of warn you, keep in mind when we say now that the statute says you can invest these funds, it still says use best efforts to make prudent investment decisions. So you're going to try and be, a little more risk averse than you might be in your personal life, depending on how you are. But talk to your experts and make sure, that makes sense for your community. An association can invest reserve funds in one or any combination of certificates of deposit or in depository accounts at a community bank, savings bank, commercial bank, savings and loan, or credit union without a vote of the unit owners. So again, the board can make these decisions, can be investing these funds. We would say, again, be conservative because you're supposed to be making prudent investment decisions. You're not trying to, hit it big and triple your money in 2 years. Let's be reasonable, prudent, all that good stuff. All right, board meetings. Now, again, we're talking condos, we're talking board meetings. Board meetings can be conducted in person. We can still do it the old-fashioned way or by video conference. The division is supposed to adopt some rules about board meetings and video conference, that kind of thing. Now, again, video conference, we now have the definition in the statute. Same kind of standard is going to apply. The notice, if you're going to do your board meeting by video conference, has to indicate that you're holding it by video conference, has to include a hyperlink, has to have a phone number for the unit owners too, because they can call in as opposed to just use a hyperlink. And then we have to have a physical address, like we said. So lots of ways for your owners to participate. If they're not computer savvy, if they don't have a computer, they're able to call in because you've given them a call in line. And there's a physical location where the unit owners can attend. So again, even if your board members are all around the globe and no one is physically on site, other than maybe the manager or maybe one board member who's sitting in the lobby, that's fine, but you have to have a physical location too. And those video conferences have to be recorded, like we said, and then kept as part of the official records. Unit owner meetings. So they changed this a little bit. Basically, your annual meeting now has to be held within 15 miles. Before it was 45 miles. Now it's 15 miles of the condominium property or within the same county. All unit owner meetings may be conducted in person or via video conference. This is the weird one. This is the weird little thing to pay attention to in this section here. If the annual meeting is conducted via video conference, so keep in mind your annual meeting, when we're talking about condominiums, your annual meeting, everybody mails in their ballot. People probably don't even really show up. They figure, okay, someone's going to tell me who the new board is. We have 2 envelopes. Everybody's voted in advance, probably mailed it in, dropped it off, whatever it is. So you might not have a big turnout at your annual meeting. And you don't physically need to have a big turnout or even proxies or all that, because as long as we have 20% that send in ballots, the election still goes, and that's usually the only thing that's being done. And then we don't care about anything else. So the meeting, if we don't get quorum, it's not that serious, essentially, most of the time. Now, this is the strange little tweak here. If we're doing the annual meeting by video conference, a quorum of the board is supposed to be physically present at the physical location where the unit owners could attend the meeting. So again, this is weird. It doesn't really make a lot of sense, because if you don't need quorum of the membership, and the annual meeting is a membership meeting, because we could still have the election as long as 20% have participated and have cast their ballots. We don't have to have quorum of the membership. Why do we need a quorum of the board there? And what if it's a board who all decided they're not going to run again? So do we need a quorum of the board that's on its way out? We don't know who the incoming board is. What does that really mean? What is that about? Strange change to the statute. Interesting the way that's kind of played out in the last, wherever 6 months, 9 months, wherever we are. Don't know that it would really be a reason to say an election was bad if we didn't have the quorum of the board there. It might just be sort of a technical violation. But if you had an election and you had plenty of people participating in the ballots and everything else was good, and we elected a new board, would it matter if a quorum of the old board wasn't there? I don't know. I don't know how that's going to play out. We haven't seen that yet, since it is sort of new. But again, that's only if the annual meeting is being conducted via video conference. So again, take that with a grain of salt. That's going to have to be recorded if we're doing video conference. And then obviously we're maintaining that as part of the official records. And division's supposed to adopt some rules. All right, so let's get into some other interesting stuff. Budget meetings. We changed the budget meeting language. A budget meeting can also be conducted via video conference. That's fine. You have to have a sound transmitting device so that people can hear each other, essentially, a mic or whatever it is. Now, this is the part that's a little strange. If the board proposes in any fiscal year an annual budget which requires assessments against unit owners that exceed 115% of the assessments for the preceding year, the board has to simultaneously propose. So it's no longer the membership can come up with their own alternative budget. The board must simultaneously propose at a budget meeting before they adopt the annual budget a substitute budget that does not include any discretionary expenditures. And that's an important term here. Discretionary expenditures that are not required to be in the budget. Now, there are some clarification points here. The calculation of whether that budget exceeds 115% excludes reserves. So that's good. Because again, getting to that 115 with these things taken out will be much more difficult. Doesn't include reserves, doesn't include anticipated expenses that are for CSRS and all of that. Doesn't include insurance premiums. So if we're taking that all out of the mix, the reserves, the insurance premiums, it is much, much harder to get over that 115. So maybe, again, this is something that's not really going to come into play for many people, but it's just weird because the board should be aware if you're planning on a budget that's over 115%, you also have to have an alternative budget that you've created, board, that doesn't contain any discretionary expenditures. So again, what a discretionary expenditure is the big question. Well, typically you're probably only budgeting for things that you think are important that are included in the budget and the things that you're supposed to be taking care of and maintenance of your common elements and blah, 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 blah. So what's a discretionary expenditure? Well, we don't really need new mulch this year. I don't know. So interesting change. Not sure how, again, haven't really seen that play out too much yet. Unit owners can consider and adopt the substitute budget at that budget meeting prior to the board's adoption of the budget that they originally wanted. If that substitute budget is adopted by a majority of the total voting interests, then it's adopted, and that's the budget we go with. If that substitute budget is not adopted, then the original budget that the board proposed is going to be adopted by the board. The board can go ahead and adopt that. And it's at least 14 days before the budget meeting where they're proposing the substitute budget. The board has to deliver the unit owners a notice and of the meeting. So interesting, like I said, haven't really seen how that's going to play out too much, but we'll see. So reserves, the change there here, they gave us a little clarification. This is a little, I think, room to breathe, which is kind of nice. They now said that basically, if you recall, before reserves, when we had just the regular reserve items, we said that the association's condos have to reserve for any deferred maintenance expense or replacement cost that exceeds, it used to be $10,000, now we've bumped it up to $25,000, or the inflation adjusted amount determined by the division. And apparently the update as of February 1st, 2026 is $25,675. So we can adjust your reserves accordingly, because $10,000, that was pretty low. Let's be real. All right. Interesting relief here too. If a local building official determines that the building is now uninhabitable due to a natural emergency, so if there's a hurricane and the building basically, gets completely flooded and now it's uninhabitable, the board can pause contribution to reserves, and they don't need a membership vote for that. That makes sense until the building's habitable again. It's a good little, relief valve, I suppose. If you needed it, you'd be in a bad spot. So, good on you that you could at least pause the reserve funding for now. An association's reserve accounts may be pooled for 2 or more required components. Keep in mind that the SERS components can only be pooled with other SERS components. So we've told everybody for years now, have a pool of your SERS and have a pool of your non-SERS. Don't mix those. So now they've made it nice and clear. SERS can only be pooled with other SERS components. And a vote of the membership is not required for the board to change from pooling to straight line or from straight line to pooling. And if there's a reserve fund basically, or in the study where it indicates your SERS, you have to again identify what's SERS, what's non-SERS. Funding SERS reserves. This one probably isn't going to happen, but if the association votes to terminate the condo, you can vote to waive the maintenance of reserves. That makes sense. SERS can be funded by regular assessments, special assessments, lines of credits, or loans. Again, we would say that was probably the case before, but now they've really clarified that. An interesting change here, or something to be aware of, if you're going to do a special assessment or a line of credit or a loan to fund SERS, now they made it clear you need a vote of your owners. Okay? So, and if you're doing a loan, like I said, a loan secured for any of that, you're going to need a vote of your owners. So before, you might have needed it depending on the language in your docs, but now if it's a loan for SERS, the statute requires a membership vote. That's going to have to also be reflected in your annual financial statement. All right. Developer controlled, we don't have to worry about that. An important thing to know is the funding from that line of credit or loan has to be immediately available for access by the board to fund any required repair, maintenance, or replacement expenses without further membership votes. So you got to have it, ready to go. Funding those SERS reserves for a budget adopted on or before December 31st of 2028. So we have a little wiggle room here. If the association has completed its milestone inspection within the previous 2 calendar years, the board, with just the approval of a majority of the total voting interests of the association, the board can pause for a period of no more than 2 budgets, so basically 2 years, reserve fund contributions or reduce the amount of contributions. So for a budget adopted on or before December 31st of 2028, so again, we have a little room, if the association completed their milestone within the previous 2 calendar years, the board could present a vote to the owners. If a majority of the owners, vote in favor, the board can then pause that reserve funding. The thinking is, well, we did our milestone inspection, So we're spending the money doing these repairs right now. Why are we also now reserving for them? Because we're doing them. So let us spend the money doing the repairs, getting the stuff done, and then we can kind of recalculate and start funding reserves for the next round, if you will. Makes sense a little bit. I like that one. We've had a couple clients that have done that because they got their milestone done and now they're spending the money on the big projects. Okay. SERS requirements. So keep in mind, a residential condo must have their SERS completed at least every 10 years. And that's, again, the 3 habitable stories as determined by the Florida Building Code. Has to include any item that has deferred maintenance expense or replacement cost that exceeds $25,000 or the inflation adjusted amount. So whatever we said before, $25,675. Before it was that $10,000 threshold, but now we've raised that up a little bit. So your SERS has to include any deferred maintenance or replacement cost of $25,675. All right, more SERS requirements. So let's see, most of this you guys probably already know. The SERS has to recommend other types of reserve fund schedules, may recommend other types of reserve funding schedules, provided essentially it's sufficient to meet the maintenance obligation. It has to be done by your, your licensed engineer, your licensed architect, or someone who is certified to do these reserve studies. Has to include the reserve funding schedule based on a baseline funding plan, provides a reserve funding goal where the reserve funding for each budget year is sufficient to maintain a reserve cash balance above zero. Again, ask these guys how to, for more information on that if you have any questions, but you're going to be relying on your experts for these SERS reports. All right. The SERS is going to take into consideration the funding method. All of that's going to be kind of built into the report. If you plan on doing regular assessments, special assessments, lines of credits, loans, that all needs to be in there too. So make sure your experts are aware of what your plan is and how you're funding it. All of that needs to be in there. You can update a SERS report to reflect any changes in the useful life. So if an item does get repaired, replaced, great. If the SERS said, hey, you have 0 years left and this is $1 million project, I'm just going to use some numbers, and you did it, you replaced the roof, great. Now we're back to, well, we don't have to fund $1 million because we just spent $1 million, maybe not. Now we're back to, let's adjust the SERS. We have another 20 years, to start funding this for our next roof or whatever it is. So that's going to change your SERS as well. So make sure your SERS is updated regularly as you're doing your repairs, as the useful life changes. Even if you do some maintenance, you might extend the life of some of these things. More SERS requirements. Again, they added a nice little change or another little edit. The SERS is not required for a 4-family dwelling. Before it said 1, 2, or 3. 4 families are added there too, with 3 or fewer stories above ground. Any association existing on or before July 1st, 2022 must have their SERS completed by December 31st of 2025. So hopefully we've already done that because that has come and gone. If the association completes their milestone or has, a similar local requirement down here, there's a lot of the 40-year, the 50-year certification, whatever it may be, that's very similar. Essentially, it ends up counting for your milestone. The association can delay performance of the SERS for no more than 2 consecutive budget years, again, so it can focus the finances on doing those repairs that were identified by the milestone before we do a SERS, because we would just have to update the SERS as soon as we got all those repairs done. So that makes sense if you think about it that way. An officer or a director, not your CAM. So an officer or director has to sign an affidavit acknowledging receipt of the completed SERS. They want it from a board member, from an officer, from a director, not from the CAM. And the division's supposed to adopt some rules about the form that's supposed to be used. All right. More conflict of interest stuff related to SERS this time. Similar to what we already talked about, a design professional or a contractor who bids to perform the SERS has to disclose if they're also going to bid on any services related to the maintenance, repair, replacement that is recommended by the SERS. Again, we're making sure everybody's disclosing everything and everybody's on the up and up, right? Same thing, design professional licensed contractor who's going to perform any services recommended by the SERS cannot have an interest directly or indirectly in a firm or entity that provided the association SERS unless they've disclosed that in writing to the association. And same penalty, if that contract comes up and they didn't comply, it's voidable. The association can terminate with a written notice. Again, no penalties, nothing like that would count. And that person, that expert might be subject to discipline under their, again, whoever governs their license. Hurricane protection. So this was a nice change because basically this gives you guys as the association, as the board, the ability to amend your documents to address this if you want, before it becomes an issue potentially. So now the language is, unless otherwise provided in the declaration as originally recorded or as amended. So unless your deck says something otherwise, and again, you can amend your deck, a unit owner is not responsible for the cost of any removal or reinstallation of hurricane protection, including shutters, essentially, if that removal is necessary for the maintenance, repair, replacement of other condominium property that the association is responsible for. So essentially, if the association has to take down hurricane shutters because they're doing concrete restoration, you might say, well, but that's the unit owner's shutters. It's their problem. They have to take it down. They have to put them back up. We're not paying for that. Well, if your deck says something otherwise, or your deck better say that, otherwise you're in trouble because the statute says the unit owner is not going to be responsible for that cost, because the association had to do it because they had to get to the common elements. They had to do the concrete restoration. And again, the board has to determine if the removal, the reinstallation is going to be completed by the unit owner or by the association, who's putting the shutters back up now that we had to take them down, now that the concrete restoration is done. The board's going to decide if, essentially, but again, it depends. Your declaration could actually indicate. So look at your declaration. If you're planning on doing any concrete restoration, this might be something that's already come up for you, but make sure your deck says what you want it to say. This one I just kind of found funny. They put this in the statute. I like it. Evacuations from the condominium. This is how you know we had some hurricane issues in recent years, but knock on wood, they weren't on this coast. In the event of an evacuation order in the locale where your condominium is located, the board can require the evacuation of the condominium property. So basically you can tell everybody they got to get out, but that's only if there's an evacuation order. Now, if a unit owner or some other occupant, whoever it is, refuses, fails to get out, and the board has told them they have to, that association is going to be immune from any liability or injury to that person or property arising from their refusal to leave, basically. So that's a nice protection for the association. All right, this is an interesting change. Now, you guys, I don't even know if people were fully aware that this was a thing now, but it was definitely a hot little topic for everyone in our fields. So managers, this is probably not news to you, but this was one of the strangest changes to the statute last year, electronic ballot voting. So if you have electronic voting, and again, if we were in person, I'd ask you to raise your hand. If you have electronic voting, you already use a platform. There's a bunch of them that you could use. If you already vote with an electronic voting platform, this doesn't apply to you. You don't really have to listen. Oh no, I'm sorry. This part does. We'll get to you in a second. They changed the statute. If you want to adopt electronic voting, it used to be a 14-day board meeting notice. Now you don't need a 14-day board meeting notice. It could just be a regular 48 hours if the board wants to decide to go forward with electronic voting. The other thing to keep in mind, now basically your owners can kind of force the board to start doing electronic voting. If 25% of the voting interests sign a petition to adopt electronic voting, the board has to hold a meeting and basically has to start doing electronic voting. Now, electronic ballots. So this is what I was talking about. So there's electronic voting through platforms. Like I said, lots of companies that already do it. There's certain safeguards in place. Your votes are going to be, blind. You're never going to know that, Mr. Jones at AOL.com voted for, Bill, Susie, and Mary. But you're going to know that Mr. Jones voted, and you're going to know that Mr. Jones is from, Unit 101, and Unit 101 cast their vote. That's all controlled through the electronic voting platform. That's been in place now for years. Our understanding is the legislature kind of wants to push all the associations to use these electronic voting platforms and just be doing it that way, because it does make life a little bit easier for your owners who, again, might be snowbirds, might be traveling, might be here or there, everywhere. It's nice when they can vote, on an app and they don't have to mail in a ballot. Mail's terrible these days. How's it going to get up to Canada and get back in time? All that good stuff. So we have a new player enters the ring here. Electronic ballot voting. Now, this is different than the platform. If you have the platform, any of those platforms, any of those companies, this does not apply to you. You don't have to listen to me for the next 5 minutes. If you don't have that, this is something you have to worry about. Now, they wanted to make it easier for people to basically vote via email. So those safeguards that you had through the platforms, those are kind of out the window. We're talking sending a ballot via email. So if you don't have electronic voting, the association is now supposed to designate an email address to receive email ballots. A unit owner can electronically transmit a ballot, so send an email, to the email address that it's designated by the association. They don't have to follow all those other rules about secrecy and anonymity and all that good stuff. Nope. They can email their vote, essentially. Now, the completed ballots are supposed to look a certain way or have certain information, so there is a little requirement here. Now, if the completed ballot has the following, then it's good and you can count it. A space for the unit owner to type his or her unit number, space for the unit owner to type his or her unit or his or name, first and last name. That's essentially what we're counting as their signature. And then in capitalized letters and in font larger than anything else, they have to have this little disclaimer. And we've put it here and it's in print, and it sounds silly when I have to read slides to you, but I will read this because when you hear it read to you, it sounds a little silly. So I like to read it for, dramatic effect. Waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy but wish to participate in the vote that is the subject of this ballot, please attend the in-person meeting during which the matter will be voted on. Legislature, they're not English teachers, so it is what it is. Essentially, it's telling everyone, hey, if you email your ballot, there's no secrecy involved. We know that, Mr. Jones at AOL.com is voting for Bill, Mary, Susie, because it came from his email address, and we know. But it has this disclaimer, and he's aware, and he's good with it, and he doesn't care that he knows that you voted for Bill. He voted for Bill, Mary, and Susie. Fine. The safeguards that are kind of lacking is our concern is, well, so does that mean, what if we get multiple ballots from a Mr. Jones at AOL.com? What if we get multiple ballots from Mr. Jones at AOL.com that say, okay, this is for Unit 101 and it's from Jim Jones, or, oh, this one's from Unit 205 from Mary Smith, but it still came from that email address? Do those all count? Good question. A lot of safeguards that sort of aren't in place when we're talking about sending an email and voting by email. So this is the concern. So this is why I think, the theory is maybe they want you to go with the electronic voting platforms because all of those safeguards are in place there. Who knows? Now, ultimately, once they send that email, they send that ballot, it has to go and be sent, it has to be received no later than the scheduled date and time of the meeting. So if your annual meeting is called for, 7 p.m., that email better come in before, if it comes in at 7:02, too bad, it's not going to work. And there's a rebuttable presumption that the association reviewed all the folders that are associated with that email address. We would tell you, and the LCAM, or the board member LCAM, somebody should provide a sworn affidavit attesting to that review. Then that's the rebuttable presumption. So have an affidavit that confirms, as their manager, I checked the, Greens condo email ballot box, whatever it is. All right. We'll skip these slides. They're in here if you need to know about condos consisting of 10 or fewer units. That typically doesn't apply to many of you, but the information's in there. There were some updates to that part of the statute as well. All right. Authority of the division. This is an interesting, expansion of their authority. Basically, now we've clarified that the division gets to have jurisdiction over some more stuff. They can investigate complaints related to milestones, the completion of repairs required by the milestones, requirement of the association to maintain insurance, condo board member education requirements. Now they can look into that too. So make sure you guys are doing all your education requirements, which I assume you are if you're here. Reporting requirements for SIRS. That's the other one that now is in the mix. So the division now has authority over all of those topics as well. If you're wondering about creating your account with the division, now you have to do that. The association has to do that by October 1 of 2025. So hopefully you've already done it, but there's the information if you need some more. Basically, division wants you to register, create the account, all of that. You have to update it. All right. There's the, detailed info to walk you through how to do it. Again, they're trying to kind of assemble all of this information, keep records. They want to know how many stories, how many units, all of that good stuff. So you have to make sure you're registered with the division if you're a condominium association. My Safe Florida Condo program, we won't talk about this too much. Basically, it was the program that, I see you, Jeff. What's up?
Keep talking. We're almost at the end of the condo stuff. So condo board members, after Emily covers this a little bit about the My Safe Florida condo program, which you already said it won't be much.
Yeah.
After this part, the condo board member certification portion of the presentation will be completed because then we get to the rest of the slides, which is the stuff for the 2 hour legal update credits for managers. So what I'm going to do now, and again, Emily, I'm sorry for the interruption. What I'm going to do now is I'm going to place the link for the evaluation post-webinar form into the chat module. So condo board members can start filling that out now. And after Emily gets to the, let me see here. After the MySafe Florida, we get to House Bill 897, which is timeshares. Condo boards don't need to stay on for that. Just managers do. So again, after the MySafe Florida condo, if you're a board member, you can go if you want to after you fill out the evaluation. Link is now in the chat. Emily, back to you.
Thanks, Jeff. All right, so My Safe Florida condo program, I have a lot of clients that were asking about this when it was created in 2024, and it seems I don't know who's actually been able to get any money out of it. It sounded good in theory, but I feel like I don't know how successful it's been because it seems all the money was gone very quickly, and I don't know who got it. But hopefully, lots of condominiums got some help. So let's hope. Basically, this was it's a program for grants to do repairs, that sort of thing. So it requires that the association have certain votes in place and take certain steps and apply to get these things. It was a majority vote of the board or a majority vote of the total voting interest. In order just to apply, you need that vote. And department created a form must be provided to all of the owners before the vote was to occur. Signature or signed disclosure form is subject to the official records. A result of any vote has to be given to the unit owners. And ultimately, you have to use the department-approved hurricane mitigation experts to inspect the property, to provide reports, to do all of that. That laid out basically who the approved inspectors are, what the reports would require. The association could choose a contractor as long as the contractor meets the standards, by general law. And basically, the association has to submit to the department for a final inspection within 1 year of being awarded one of these grants to get the final grant amount. So they had 1 year to kind of get things organized. So what they did change, what they clarified a little bit here, they amended that definition of a condominium to exclude detached units on individual parcels of land, because sometimes there are condominiums that fall under that category, but that's not who they wanted applying here. So they're excluded. Prohibits a condominium association from applying for the grant unless they've complied with their milestone and their SIRS. So another thing forcing everyone to get their milestone and SIRS requirements done. And prohibited condominium associations from applying unless the windows are established as common elements. So I guess, again, they kind of want to do maximum impact here. So if the windows are part of the common elements, bigger burden for the association, obviously, more of a reason they would need the grant. So I think that was the thinking. Now, the other change, it provided that only 75% of the unit owners instead of 100%, because who gets 100% of unit owners to vote on anything? That was a crazy requirement. 75% of the unit owners have to approve the application instead of 100%. Good. And all of the grants must be matched on the basis of $1 provided by the association for every $2 provided by the state towards the actual cost of the project. And then there were some other tweaks about the improvements that are eligible for funding and that sort of thing. All right. So that's the end of the condo section. Hint, hint. Now, if you're a CAM, you got to stick around for a little while. Again, it's not a lot more, but stay with me here. House Bill 897 relating to timeshare plan management. All right. They need you to know about this, so here we are. So basically, again, similar theme that you're going to see here. They just put in that timeshare management firms and their employees have a duty to discharge, must be discharging their duties in good faith with the care of an ordinarily prudent person. I would hope you were already doing that, or they were already doing that, but now we've clarified it, and it gives them an exemption from monetary damages as long as that is essentially what they're doing. The board is supposed to meet at least once a year, and there's certain annual disclosures that are now required. This is all for timeshare, so again, if you're only condo, don't pay much attention to me for the next few minutes. Then there's some conflict of interest language that they added in there, and they stipulated that management firms and the employees are governed by certain sections of the statute, laid out a framework for how the managers are supposed to handle owner communication, owner list, things like that. So some technical stuff if you work with timeshares, that's important to know. Okay. Senate Bill 108 relating to administrative procedures. Again, I have to say these things because we have to tell you about this in order for you to get the update credit. So don't be mad at me. Okay, administrative procedures. This is exactly what it sounds like under those words, administrative procedures. So certain state agencies now have to provide certain notices. They have to adopt certain guidelines. They're supposed to be reviewing their rules annually, adopting standardized procedures for rulemaking. Okay. Provide provisions for expedited reviews of certain types of rulemaking. State agencies will be required to maintain a clear and accessible online repository of all the proposed rules, public comments, and final decisions. So that's nice. All right. Okay, this one's my favorite. Senate Bill 472 relating to education and correctional facilities. And it's my favorite just because it sounds most interesting. It's more exciting than talking about administrative procedures. So here we are. Okay. Requires the correctional education program to develop a plan allowing inmates to receive credit towards professional licensure by completing qualifying classes in correctional facilities. So at the correctional facilities, now you can get certain credits and basically work towards getting some sort of professional license. The program is supposed to coordinate with the DBPR and the licensing boards to make sure that this coursework and the things that they're offering can fulfill professional requirements and help people post-release potentially work towards some sort of career or some other goal. So like I said, that's my favorite one. I think that's kind of interesting, right? Senate Bill 948 relating to flood disclosures. This might be something that is probably more relevant to most people than what we just talked about. Basically, landlords, sellers, developers have to provide detailed flood risk information to prospective tenants, buyers, lessees before any rental agreement or sales contract is finalized. Disclosure of known flooding history, any filed flood insurance claims, federal, non-federal assistance received for flood-related issues, all of that has to be disclosed as part of any rental agreement, sales contract, all of that. And then flooding is defined pretty broadly. So really, even if just a claim is put in, it's important. It has to be disclosed now. And tenants have the right to terminate a rental agreement if they suffer substantial damage due to non-disclosure. So important. Okay. See, we got it done within an hour and a half.
Not even got it done because I was blabbing for the first 8 minutes. So you got it done in about an hour and an hour and 10.
Like I said, to me now, this kind of seems like old news.
Yeah. So great job, Emily. So before folks, we had 500 of you here today, and there's about 28 questions in there. We'll get to a few of them. We're not going to be able to get to all of them in the time left, but I do need to take another minute before Emily gets to some of the questions. I want to reiterate to everybody, I said this at the beginning, the Q&A, or maybe I didn't say it, the Q&A is bonus time. You are not required to stay for the Q&A part. It's not something we have to do. We just like to do this for with the extra time that we have, when the presentation ends a little bit earlier. So after you fill out the evaluation using the link that was placed into the chat several times. After you do that, you can go. You do not have to hang out for the Q&A if you choose not to. You'll learn some good stuff if you do, but you're not required to stay. We are sensitive of your time and know you might have other things going on. So, with that said, let's see here. Oh, and when Emily's done with some of the questions, I will remain on for anybody who might be struggling with the technology aspect of the evaluation. I'll be here to answer questions on that and help you out with that. I'll share my screen, show you how to do it if you're struggling with it. So hey, you want to get to some of the questions, Emily? Have you
Yeah,
tried to look through some of them?
let me see. So someone said if there's a management contract that renews annually, should there be an addendum stating the 468 language concerning the CAM? I would say yes, you probably should. I know a lot of those management agreements do automatically renew, but ultimately the change was effective as of July 1st. It says every management contract should have that extra sentence now. So anyone that has come up for me for clients, I've made sure, even if it was literally the same contract rolling over, hey, can we stick this sentence in there in the 12 font and all of that and do a new contract basically. And managers, either they've forgotten about it honestly, or they don't have an objection to it because now they're supposed to do it. So I would have them do an addendum if they think of it, because I wouldn't want it to be an issue down the road. Someone said, is there a DBPR link to view all the associations that an LCAM represents? And that's interesting. I don't know if there is. I would have to play around. I've never looked at it from that perspective. You can, like we said, search the license, make sure the person is licensed and what company they work for. But I don't think you can actually check which associations they're affiliated with.
I'm not aware of that yet either, and I'm on
Yeah.
there all the time. But that's a good. I'm going to look that up. I'm going to see if you can. If there's a way, I'll figure it out.
Right. I don't think so. I don't think they've quite gotten that savvy.
Emily, I'm going to take one of these questions. Larry, who just posted a question, will slides be automatically, or do we have to request after you fill out that form that we've gone over a few times already with the link in the chat? After you fill that out and submit it, the confirmation screen of a successful submission appears on your screen. One of the links on that page is the link to save the slides that you just saw. Back to you, Emily.
Right. So somebody said a question that we sort of talked about a little bit. Again, keep in mind with some of these changes, my answers are pretty much I don't know, because they are new changes and we don't know how they're going to be sort of handled or interpreted. But someone said if you do not turn on the video setting for the Zoom and you only use the audio, does it have to be recorded when we're talking about the video conference? So this was another sort of a debate because, again, groups of lawyers, we try and find loopholes for everything.
Hmm.
The definition for video conferencing was audio and visual. So, by that stretch of the imagination and that definition, if you don't have the recording on for the visual, then it's not a video conference. And before all of this and before the Zoom came into play,
Yeah.
people would teleconference in. So they would just, hey, either they'd have the little, phone in the center of the desk and they can have people on speakerphone, that kind of thing. Or you can even have your board member, called in and on speaker, and that counts as them being present and them participating. So to me, that hasn't changed. So if you're just audio, if you're just basically teleconference, then it's not a video conference. And then in theory, you don't have to record it. But if it is via Zoom and you've just sort of turned everybody's cameras off, that's where we get into this. Well, does that count as a video conference? Because it was, but we turned all the cameras off.
Yeah.
I don't know. I don't know how that'll be, handled if there's a challenge. But if you don't want to have to record it, then just do it through a teleconference.
There's another curveball in this edition of Stump the Attorney.
Yeah.
So say on the agenda, they put official meeting place, the grand ballroom. For your convenience, the meeting will be streamed on Zoom if you can't make it to listen to what's happening. So I've heard, not from our firm, but I've heard some attorneys say on other webinars that since the official meeting place is the room and not the Zoom, it
Right.
doesn't need to be recorded. But then if you're taking questions from people on Zoom,
Right. And we don't know. And I'm assuming, it's one of those things where when it comes up, if the division asks and is asking what's going on and why people are doing what they're doing and why didn't you keep a recording and all of that,
Yeah.
it just looks bad. It just looks like you're trying to keep secrets. I I wouldn't necessarily want to do that. The division's going to wonder why you weren't keeping those. Why wouldn't you record it? Why wouldn't you keep those meetings?
Right.
So
What are you trying to hide?
you're not trying to hide anything.
Right.
So what's the difference? So record it and keep the recording and post the recording and all of that. It has to be posted on your website for a year, but it's kept in the official records. Um, so it is an interesting one. That's another one that everybody kind of we're also kind of figuring that out because again, this is the first year that it's really been a thing.
Yeah.
Um,
Well, Amanda asked, what if you don't have a camera? Well, I think we just answered that. If even if it's just audio, just record it.
if it's straight up just audio and it's not hosted by video conference, you're not required to.
No.
The other
Okay.
part of it is people will say, it's an extra burden because we have to upgrade our Zoom package or whatever it
But
is, and we have to pay more for the storage or
well, hang on, hang on. I think again, folks, I'm not an attorney. I just love talking with Emily because we it's like the light bulb over the head. The fact that the law says you have to, if you're doing a video conference, but you still have to provide an audio link. The
yeah,
fact that that is there to me, if I was an attorney, would be like, no, you got to record it, even if it's audio only, because they're saying you have to have an audio link as part of the join in thing. So again, it's so confusing.
right. And the other option too, as we've told people, is you can go back to the old fashioned, well, we don't want to pay to store everything. We don't want to pay to record everything. We don't want to use the platform. It's costing us money.
Yeah.
So we're just going back to the old fashioned,
Yeah.
come to the lobby at, 7
Yeah.
p.m., second Tuesday of the month. And
Yeah.
that's our board meeting from now on.
There you go.
That's the other way to do it. And you are going to have owners who say, hey guys, can't you do it by Zoom? I don't live here. I'm only here part-time. So it depends. It's really up to the board. If you guys are okay with that and your owners aren't complaining, then who cares? Do it the old-fashioned way and
Yeah.
keep doing what you need to do. But you
Yeah.
probably will get some owners who say, well, why can't you host it by Zoom?
It's hard to go when you do something, it's hard to go backwards.
Yeah. Yeah, people have gotten a little spoiled now. They want to be
Yeah.
able to jump in, even though they're, like I said, on a cruise ship in the Mediterranean.
It's a rough life.
I, All right. So a lot of questions about that and about the video. I do like that someone said, has the Florida legislature lost its mind?
Yeah, I saw that earlier, and that's why I had to turn my camera off because I was cracking up.
Do they understand the damage they've done to the Florida condo
Come on,
market?
man. Everything that comes out of Tallahassee makes sense. Come on.
They listen, part of the spiel last year was they were trying to give some relief and this whole thing with the
Yeah.
milestone and the SIRS and pausing that funding, having time to pause and wait for your SIRS while you're working on your milestone. That's how they were selling it. We're giving the condos some relief. Um, as a practical matter, yeah, everyone's entitled to their opinion. I don't know. I don't know what the effect will be. We want to keep buildings safe, right? So, let's see. What happens if our docs say the $10,000? Does the statute of the 25K trump the docs? That's interesting because I wonder where your documents would say that. But ultimately, I mean, you have to keep the reserves pursuant to statute, but if your documents say something additional, you probably have to follow that, but I'd want to see how that's worded. Let's see. Somebody said, and I've heard owners complain about this too, that the president and vice president do meetings during business hours, but you can't participate because you're working and those are working hours. Is there something where, what can we do about it basically? And really, unless there's something in your documents that says, that every board meeting has to be at 6 p.m. on a work night, on a, weekday or something, then the board members can schedule the meeting for when they want. And I know there are lots of communities where different days, different times just suit their owners better, suit their board members better. That's really up to the board unless there's something in your bylaws that says otherwise. So
Let's do there's 1 minute left in the advertised time, so take one more question.
oh goodness, that's so much work.
The pressure's on.
I know. I feel like I need to find a good one. All right, so someone said with voting online, if we're not doing it now, does the board only need to vote to approve it, or do we need the owners also to approve it? So like we said, now voting online really means two different things potentially right now. You either have that electronic voting platform in place, which means you're working with probably a vendor, a third party company that's running it for you. And again, I think that's the way the legislature is sort of pushing everybody now. Or now the other option is if you don't have one of those, your owners can vote by sending in an email, thanks to this lovely new change in the statute. So if you want to do the electronic voting where you have that platform and you have that vendor and those safeguards are in place and they're making sure everybody's registered and it's one vote per, email address and all that good stuff, then it's just a board vote to set that up. So the board can do it, members don't have to be involved. But then, like we said, there was a little change to the statute where the membership can basically petition the board to start doing it if the members want to kind of force the board's hand a little bit. So that's a board vote though, and it's just a 48-hour notice. The board can decide to move forward. There are certain things that have to be set up properly, but if you're working with one of those vendors, odds are they'll kind of walk you through the process. But there's certain safeguards, like I said, certain procedures that need to be followed. You have to adopt a resolution. You have to notify your owners once you've done it. They have to be able to opt in and use the system, all that good stuff. So maybe get help from your counsel, but also you're going to want to talk to some of those vendors first before you really decide to move forward. All
And
right.
then our COA is required to post board meetings on its website. I think we covered that ad nauseum, but the videos for 1 year, right?
Yes, 1 year.
Videos for 1 year, and I'm guessing you don't mean notices. Obviously, the notices are part of the documents and they need to be on
Right.
their notices and agendas, Carlos. So, and if any of you are newer board members, I had one person earlier chatting with me who was told that this was the certification class, said, "Oh, this is the 1 hour, not the 4 hour." Well, if you need the 4 hour class, we're doing that a week from today. So if you're a newer board member who needs the 4 hour monster certification class, bring a bottle of pee in because you're not going to be able to get up for 4 hours. Don't drink a lot of fluids. That's next week, the 24th, with KBR. I think at 10, we start at 10 a.m., I believe. Carlo, yeah, notices, agendas, that all needs to be on the website, in addition to your official notice location on property somewhere.
Right.
So Emily, great job as usual. Thank you.
Thank you guys. Thanks. It's like I said, to me, this feels like it's like old news. So it was nice to revisit it a little bit. It's been a minute. So thanks
Yes,
for
yes.
having me. Mariel, always good to see you. All right. I'll leave you
Bye,
guys
guys. Thanks, Emily.
in your
You take
hands.
care. Emily, you take
Thanks,
care.
everybody. Bye.
Bye-bye. And Mariel, you want to give your parting words for Ace, and then I'll remain on and hang out to do have a few people with technical questions.
Yeah, just wanted to say thanks to everybody who joined us today. We hope to see you guys next week. We'll be here all summer long every Wednesday. So we hope to see you back again.